Supported decision-making is an alternative to the use of court-based guardianship actions that allows an individual's trusted friends, family members, and professional advisors help them to understand their circumstances and the choices they face so they can make their own decisions without a guardian. Supported decision-making should be used when individuals are still able to communicate and express their wishes in some way. For example, verbally, through sign language, written down, by blinking, etc. APS's interaction with May is an excellent example of how supported decision-making can allow a customer to make decisions for themselves. May was an 80-year-old woman with early onset dementia who needed a higher level of care than she would be able to receive in her own home. Her physician recommended nursing home level of care and wanted APS to file for guardianship of May. APS interviewed May and discussed her situation with her. Despite her condition, she was able to understand her circumstances and the options before her. She agreed to move into an assisted living facility where she could receive the services she needed. With the use of supported decision-making, APS was able to provide May with the services she needed without filing for guardianship. If supported decision-making is not possible, there are several alternatives to a guardianship that are less restrictive while still offering benefits to a vulnerable adult. Examples include the use of a healthcare directive, representative payee, or appropriate banking tools. Regardless of what alternative is selected, having multiple people involved can help prevent maltreatment and reduce stress or burnout for the supporters. Legal guardians hold a significant responsibility. Their actions may be reviewed by a judge, they must account for the money they spend, and they must involve the vulnerable adult in decision-making as much as possible. Guardianship can be the appropriate response in some circumstances, but it is never the easy answer. A legal guardian has responsibilities and restrictions. As to the responsibilities, a legal guardian should follow the court order. They should involve the vulnerable adult as much as possible in decision-making and act in the best interest of that individual. Also, a guardian must file an annual account of how they have handled the vulnerable adult's finances. Now for the restrictions. A legal guardian should not spend the vulnerable adult's finances or assets on themselves or others. A guardian cannot withdraw from their duties unless the guardianship is dismissed by the court, and a guardian should not abuse, neglect, or exploit the vulnerable adult. There are certain circumstances where a legal guardianship is needed. Filing for guardianship is appropriate when supported decision-making is not an option, meaning the individual is unable to participate in making decisions regarding their care or finances, and if there is no one else who can or will consent for the vulnerable adult. A Title 43A guardianship, the type of guardianship APS would obtain of a vulnerable adult, is always considered the last resort. APS will only file for guardianship when the individual lacks capacity to consent to receive protective services, consent cannot be obtained from anyone acting as the caretaker, the individual is at substantial risk of death, immediate and serious physical harm, or significant and unexplained depletion of the adult's estate. A Title 43A guardianship is temporary and not meant to be long-term. The time frames are 72 hours, 30 days, or 180 days. This differs from a private guardianship, which is typically permanent. The responsibilities of APS in Title 43A guardianships depend on what type of guardianship is granted. If the guardianship includes the estate, APS will be responsible for managing the vulnerable adult's finances, securing their property, redirecting mail, and completing an inventory of all assets. APS cannot release property to the family or allow the family into the home unless approved by the court. If the guardianship includes the person, APS will be responsible for all medical decisions and placement approved by the court. However, APS cannot sign a Do Not Resuscitate or DNR order for the vulnerable adult. Although the goal of supported decision-making is to use alternatives to guardianship actions, there are times when a Title 43A guardianship is needed. In those situations, APS still uses the principles of supported decision-making by involving the vulnerable adult in decisions as much as possible. For example, if nursing home placement is needed, the APS specialist would ask the vulnerable adult about their preference for placement. Supported decision-making is always the best option because it allows the vulnerable adult to receive the help they need while still retaining their civil rights and centering their desires. If you would like additional training on APS, please send a request to communityaps@okdhs.org.